Caribbean Court of Justice. Caribbean Court of Justice, Original Jurisdiction, CCJ application number 2 of 2018 between Trinidad Cement Limited and Arawak Cement Company Limited versus the State of Barbados and Rockhard Cement Limited. CCJ application number 1 of 2018 between Rockhard Cement Limited versus the State of Barbados and the Caribbean Community. For judgment on the derogation issue this morning. Can we have the appearances for the court, please? Thank you.
Good morning, Mr. President, Your Honors. Should it please you, Mr. Reginald Armour, Senior Counsel, leads me, Rafael Lejoda, on behalf of the claimants in TTOJ2018-002. Your Honors, let me first apologize for Mr. Armour's absence. He's out of the jurisdiction. Secondly, Your Honors, I noticed that the court is robed. Let me please apologize for not being robed up here. You need to seek your leave to continue to appear before you.
Yes, leave is granted.
May please the court, Mr. President, my honor, I appear on behalf of the State of Barbados. Apologies for Ms. Anita Jackson, who is on sick leave.
Okay, for some reason you're breaking up just a little bit.
I apologize for not being moved. I was saying I was appearing on behalf of the State of Barbados and extending apology for Ms. Anika Jackson, who is on sick leave.
Yes.
I would also like to apologize for not being robed at present. I wasn't aware that this required the robing. I do have my robes with me. So,
no, we wouldn't expect you to put them on now.
okay, thank you, Mr. President.
Okay.
Your Honors, I appear for Rockhard Cement and with me is Ms. Simone Mayhew, and apologies as well for not being rude. We were not aware the matter would be open court today.
Yes, apologies are accepted.
Your Honors, should it please you, I am O'Neill Francis and I appear on behalf of the Caribbean community. And I'm led by Dr. Carlita Babshafer, who is joining from Barbados. I also extend our apologies for not being robed.
Yes, apologies are accepted. That's the extent of the appearances, I believe. Yeah. Okay. Good morning, Council. And we have a number of visitors to the court. This week is actually our anniversary week. The court is celebrating its 14th anniversary this week. Yesterday was actually the anniversary date. And we welcome you to the Caribbean Court of Justice, those of you who are visiting. This morning, the only matter which is on our agenda is the judgment on the issue of the derogation in respect of the cement that was imported into Barbados, and for which the State of Barbados had sought a derogation from the common external tariff. I'm going to read a summary of the judgment of the court. This summary is not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. The court's reasons are embodied in the formal judgment, which will be given to the parties and placed on the website. In 2001, the Council for Trade and Economic Development, quoted, granted the State of Barbados a derogation in respect of CARICOM's Common External Tariff, CET, so as to permit Barbados to levy a 60% bound rate on tariff headings 25.23 of the CET schedule. Those headings describe, in particular, quote, Portland cement, cement fondue, slag cement, super sulfate cement, and similar hydraulic cement, excluding white Portland cement 2523.31. By customs tariff amendment orders enacted in 2001, 2004, and 2009, Barbados legislated a 60% rate of duty on tariff heading number 25.23. The 2004 and 2009 orders specifically prescribed a 60% CET on cement classified as other hydraulic cement and building cement gray. These types of cement are found in the subheadings to tariff heading 25.23 in the CET schedule. Subheading 2523.90.00 provides for a CET rate of 0 to 5% on cement classified as other hydraulic cement. And subheading 2523.29.10 provides for a CET rate of 15% on cement classified as building cement gray. On October 8, 2015, the government of Barbados decided it would no longer apply the derogation from the CET in relation to other hydraulic cement. The government therefore reimposed a 5% rate of duty on that cement, consistent with the CET for subheading 2523.90.00. Although the 2009 order was never repealed, the state levied the 5% duty it classified as other hydraulic cement on cement imported by Rock Hard Cement Limited, RHCL, a company incorporated in Barbados which engages in the importation into that state of extra-regional cement. Trinidad Cement Limited, TCL, and Arawak Cement Limited, ACCL, both regional manufacturers and distributors of cement subject to community treatment, brought an originating application against Barbados, alleging that Barbados had breached the revised Treaty of Chaguaramas, the RTC, when it, among other things, unilaterally reduced the 60% rate of duty on cement falling under subheading 2523.90.00, that is, other hydraulic cement, without first consulting the Council on Trade and Economic Development, the Secretary General of the Community, TCL, and ACCL. RHCL also brought an originating application against Barbados to seek orders and declarations that, among other things, would direct Barbados to reinstate or apply the CET rate of 5% in respect of RHCL's blended hydraulic cement classified under CET tariff heading 2253.90, and 2, orders that Barbados did not require the approval or sanction of COTED to re-implement a 5% rate of duty on other hydraulic cement. In both claims, the state of Barbados submitted that the derogation could not have included other hydraulic cement, primarily because there was no expression of other hydraulic cement in the terms of the derogation granted by COTED as specified above, and that when the government decided to reduce the rate of duty from 60% to 5% in 2015, it was based on the misapprehension that the applicable rate of duty on other hydraulic cement was 60%. The court considered 2 issues. 1, the scope of the derogation obtained by Barbados, in particular, whether that derogation included other hydraulic cement, and 2, whether a member state that has obtained a derogation from COTED to increase an applicable tariff to a rate beyond the CET is required to obtain the approval of that body in order to reimpose the CET. The court held that the derogation that was granted to Barbados included other hydraulic cement. In making this determination, the court examined the scheme of the community's common external tariff and its rules of interpretation, as well as the World Customs Organization's explanatory notes in respect of heading 25.23. The court noted that the general rules of interpretation specify that the process of classification of goods under the CET regime entails first the identification of an appropriate tariff heading, followed by the identification of an appropriate subheading. Thus, it was the subheadings that would specify the applicable common external tariff. Further support of this proposition was found in the report of the World Customs Organization, prepared at the request of CARICOM to classify cement distributed by RHCL, TCL, and ACCL. In that report, the World Customs Organization accepted that RHCL, TCL, and ACCL's cement, which included subheading 2523.90, that is, other hydraulic cements, fell under heading 25.23. The court also considered the fact that tariff heading 25.23 did not have a corresponding CET rate of duty, and as such, Barbados could not have sought a derogation in respect of that heading alone. Additionally, the only logical conclusion from the express exclusion of subheading 2523.21, white Portland cement, by Barbados in its request to COTED was that Barbados would equally have made an explicit reference to subheading 2523.90 if the intention was to exclude other hydraulic cement from the derogation. The court agreed with the submissions that there was no requirement for a state to receive the approval of COTED to revert to the CET. There was, however, an implied obligation on member states to give COTED reasonable notice of their intention to do so. This should include information such as 1, the date on which the member state no longer required the derogation, and 2, the date on which the member state would apply or reapply the CET. This was, according to the court, reflective of good administrative practices, preserved the sovereign autonomy of a member state, and ultimately enhanced the overall functioning of the CSME. It also engendered confidence in the private sector. Without reasonable and adequate notice, a regional manufacturer supplying the regional market would not enjoy the transparency, certainty, and predictability required for tariff regimes to be compliant with Article 10 of the General Agreement on Tariffs on Trade, or indeed with the ethos of the revised Treaty of Chaguaramas. Turning to whether there was reasonable or adequate notice in this case, the court noted that there was no evidence that the Secretary General or COTED had made inquiries of Barbados as to the application of a 60% bound rate, or that Barbados had formally informed COTED of the reimposition of the CET on other hydraulic cement and the date of that reimposition. The court was, however, satisfied that ACCL and TCL were aware for a significant number of years of Barbados' intention and decision to reduce the rate of duty on importation of other hydraulic cement, as evidenced by correspondence between ACCL and the Minister of Trade, Industry and Commerce, which confirmed that ACCL had, quote, no objection to the reduction of the 60% bound rate on imported cement to a percentage equivalent to that of the CET rate of 15%, unquote. The court briefly addressed RHCL's submissions on the failure of Barbados to amend its domestic law to accord with the revised Treaty of Chaguaramas obligations. The court reiterated the principle expressed in Shanique Myrie the cases of Shanique Myrie and that of Tomlinson, that the mere existence of domestic laws apparently in conflict with treaty obligations does not necessarily constitute a breach of the treaty. Any breach stemmed from how the law is applied or not applied in practice. In the circumstances, the court expected that the state of Barbados consider amending its domestic legislation to bring it into line with its treaty obligation so as to impose a 0 to 5% CET on imports of other hydraulic cement. Finally, and without prejudice to the pending determination of the proper classification of RHCL cement, the court acknowledged that its findings above finally disposed of the dispute regarding the tariff applicable to cement imported by RHCL into Barbados, and the court discharged an interim measure granted on 17th July 2018 requiring Barbados to apply a 60% rate of duty on other hydraulic cement. That is the summary of the court's decision. Is there anything that anyone wishes to please?
Please you.
Mr. Wood?
Yes. There are a few issues that I have to raise consequent on the judgment. And I'll deal with them each action discreetly. The first action is the action brought by Rock Hard Cement against the state of Barbados, BBOJ number 1 of 2018. The court has observed in its judgment that we have substantially succeeded on that claim, and I would only add that the perusal of the defense of the state of Barbados to that claim raises only that the domestic law of Barbados reflected the CET rate of 5%. That was the substance of their response to the claim. So, in the circumstances, I also know the court's observation about hoping to avoid unnecessary litigation. But I would ask the court to direct that we proceed to assessment of damages if necessary, specifically to recover the 60% duties paid to date. I hope that that would be a matter that could be worked out consensually to have the duties refunded.
Mr. Wood, on how many occasions was 60% paid?
So far as I'm aware, there were 2 shipments. I would have to get details on that, but I think it's 2 shipments.
Yes.
Mr. President, it is my understanding that 5% was always charged. I stand to be corrected. I'm not aware of the 60% ever being levied.
Sorry, I didn't get that.
Mr. President, I was saying it was my understanding that the 60% has never been levied. It's always been the 5%. I stand correct. I mean, I will check with the custom, but that was my understanding.
Okay, so there is here an issue of fact which seems to be unclear, and the tenor of the court's judgment is that the 60% that was charged was improperly charged. So I think I would leave it to the parties to work out among themselves whether it was charged at all, whether it was charged on 1 occasion or 2 occasions, as the case may be. And I expect that the parties would resolve that issue between themselves. If it can't be, then if you've made reasonable efforts to, then one party or the other can bring the matter before us.
Right. So I was just saying that the appropriate worded order allowing us to return to the court if necessary, I was suggesting it be made as part of the order. I would expect the parties to be able to work this out, because my understanding is that 60% was only applied after the grant of the interim measures. So to the extent that it was paid after that, it would have to be refunded.
Mr. Wood and Council generally, could I just suggest as well that the interim measures order contains all of the circumstances which I think have been raised by Council. In other words, the order specified specifically that the Rock Hard Cement Limited would be entitled to recover damages, which of course would include payment of the 60% if in fact it was found that 5% was payable. So that it's a matter purely of fact and of calculation. I would be surprised if you needed to come back to court on this. If you have to, of course you have to. But the point is that if you look at the interim measures order, I think it is very clear as to what the entitlements are for Rock Hard Cement Limited and what the obligations are for the state of Barbados and for TCL.
Very well. That was the second matter that I was going to, which is that would be on the 02 of 2018 TTOJ, because one claim is against the state of Barbados by Rock Hard, which really arose out of the grant of the interim measures order. And then there is the undertaking in the interim measures order, which I would also ask that they be acknowledged, that if the parties can't work it out, then we would come back on that in TTOJ2 of 20. What I'm saying may all be redundant, but out of an abundance of caution, I think I should say.
Yes, well,
And then,
Mr. Wood, there's an explicit order in the interim measures judgment that speaks to all of this. It says the applicants shall indemnify the respondent and the intervener for any loss or damage sustained by them if it be proved that the trial of the originating application that such loss or damage was incurred by the unjustified imposition of these interim measures. So that
but the money was paid to the state.
yes,
So I would expect that the first recourse would be to the state to refund it.
yes. So
Which is
what,
under
are you asking
claim.
for an order that says something that the parties have liberty to apply in
Yes.
relation to this order?
Yes, in relation to BBOJ 2018-01, which is the claim by Rock Hard against the state of Barbados.
Okay.
The interim measures speak for itself.
Okay, well, we have no difficulty in including a clause of that nature to the order that the party shall have liberty to apply to the court for further directions in relation to the working out of this order or something along those lines. We will refine the language and include it in the formal order which will be sent.
I'm obliged.
I,
And then
Mr. Wood, I would say I would agree with that. But as I see it, this is kind of a step-by-step procedure. So even if there are some unresolved issues, we have not given a final judgment yet. So in my view, there's no problem at all with a clause as you mentioned, but even without the clause, as I see it, there would still be space to deal with that because we have to come to a final judgment, which I think will incorporate it in one form or the other, all the other decisions that have been taken along the road anyway. So,
Yes.
for you and all the other parties, this is not the end of the road, so to speak. That will be after we have dealt with the last major issue of classification, but still, if there are some unresolved issues, I think the court would have no difficulty with dealing with those, because in the end, we want to give a judgment which resolves all these issues.
Yes, I understand that, my lord, but in my view, the court's judgment has substantially disposed of BBOJ 2018-01, which is rock hard against the state of Barbados. There is no classification issue raised in that. So,
in that case,
as I say, what I say is out of an abundance of caution.
Yes.
That action has, as far as I'm concerned, been disposed of.
Yes, that is the case, and we have no difficulty in including that part of the order that in the order, something that is to the effect that the parties have liberty to apply.
I am obliged. And the other matter that I would like to raise is a question of costs. I believe it would be appropriate in this case for costs to follow the event and for costs to be awarded to Rock Hard Cement in respect of the derogation issue that has been determined. And that would be particularly in TTOJ 2018 02, the PCL Arawak claim.
Yes, well, we agree with you on that. We will ask the parties to first attempt to agree costs, and then if there is no agreement, then to make submissions to the court on the issue of costs.
Your Honors, if I could just seek clarity on that last pronouncement of the court. Is it submissions or parties to agree on costs related to the derogation issue alone, or would it catch the previous interim measures applications and discharge applications and so on? Because I think it's all wrapped up. So it may be, if I could suggest, subject to, of course, learned Queen's Counsel, it may be that it may be easier to treat with costs when you have a substantive all-around decision following the trial in June. Because the way I see it, Your Honors, is everything is more or less intricately wrapped up. So I would suggest, much in the same way the court reserved costs when the applicants were successful on the interim measures application, that the court again reserved costs pending the substantive decision.
Yeah. Okay, it seems to me that we can segregate the costs on the interim measures issue and leave until the end of the substantive proceedings in all the other matters the issue of costs in those other proceedings, so that the issue of discussion on costs and an application submission to the court on the issue of costs would only relate at this point in time to the interim measures application.
Added, please, Your Honor.
And again, us in BBOJ 2018-01, which we hope won't come back.
Sorry, I didn't get you, Mr. Wood.
No, I'm saying there's also the cost in BBOJ against the state of Barbados. Rock hard against the state of Barbados.
I think it would be best to leave the whole cost till after. Yeah, the whole thing.
There are two schools of thought. One is that we leave all the costs until we complete the substantive measures. The other is that we simply segregate the interim measures alone and deal with the costs on that issue and leave all the rest to the conclusion of the substantive matters. Can we hear you on those two options?
Well, Your Honors, I would just, sorry, for the claimant's perspective, I would just repeat the earlier submission that the claimants are in favor of treating with costs on a whole once the substantive decision has been delivered in June.
Yes, Mr. Wood?
Yes. Your Honors, in my view, it is appropriate to deal with costs in respect of the derogation issue as a discrete matter. The whole purpose of having determined that as a preliminary issue was to shorten the proceedings, and it has, for all practical effects, disposed of at least one claim, which is a claim brought by Rockhard against the state of Barbados, and has substantially disposed of the other claim, which is Arawak Cement against the state of Barbados, but for the classification issue. So it has been a discrete matter, and that has been determined, and I think it is a fair thing to award costs on that issue in both actions and also in respect of the interim measures.
Your
Yes,
Honors,
Barbados?
President, with respect to the state of Barbados, also the position is that
Yes. Barbados?
Mr. President, the position for the state of Barbados, yes, Mr. President, the state of Barbados is that the issue of costs be dealt with when everything is finally determined. That would be determined.
Okay. There's another issue which I'm grateful to my colleague for pointing out. Mr. Justice Barrow was originally is a member of this panel, and unfortunately he couldn't be here today. But of course he concurred fully in the judgment that we gave. In his absence, it wouldn't be proper for us to make these kinds of determinations. So we would not make any determination on the various issues which we've just been discussing. When we can meet with him, we will let you know whether our decision is that we would receive submissions from you on the discrete issue of the interim measures, or whether we would leave everything until all of the substantive issues have been determined. Is there anything else?
No, please, Your Honor.
Very much obliged, Your Honor.
Yeah. Okay, well, in that case, we will adjourn.
Court rise.
Much obliged.